Susan Lorincz was due in court this morning. I don't know if she actually made it or not, but I do have some updates of what occurred today. So let's kind of reintroduce you guys to the case a little bit with this latest news update.
And we now have new details this afternoon about what happened before a white woman shot and killed her black neighbor. Susan Lorincz here shot and killed Ajike Owens when she came to confront her for allegedly throwing a skate at her children.
Now, new documents give insight into what Susan Lorincz says happened in the years before and the day of the shooting. West News' Michelle Meredith is live in the studio with those new documents. Michelle.
Well, right off the bat, you get a feel for the intense hostility between Lorincz and the Owens family. Through the report, we learn in the years leading up to the shooting, Lorincz said she was upset that the children leave their belongings around her apartment. She admitted calling the children derogatory names, filming or photographing the children, and raising her middle finger at them. Lorincz told investigators once Owens pulled up a trespassing sign she had and threw it at her. Then it all came to a head on June 2nd. Lorincz is accused of throwing skates at Owens' children and taking their iPad. According to Lorincz, Owens came to her apartment and banged on the door hard enough to cause things to shake, thought Owens was going to come through her door and kill her. Lorincz admitted, even though she could see Owens did not have a weapon, Lorincz got out her Remington 380 and from her kitchen fired one shot through the door, heard a sound indicating Owens had been hit. Lorincz tried to use Florida's self-defense law and even says she researched the law years before the shooting and on the second day she was interviewed by law enforcement. And in a move that was very controversial, she was eventually charged with manslaughter. Now, in a later interview, Lorincz said she had no memory of calling the kids racial slurs, and she said if she did, it just slipped out.
So that's where we are with this one. Here's Ajike Owens, the victim. She was 35 years old, a mother of 4. Her children were ages of 3 to 12 years old. And of course, they were outside a lot playing with the other children in the community. It looked like a villa, kind of. If they want to call it an apartment complex, that's fine. They weren't like townhomes. They were more like 1-story little villas. But I did see that someone referred to them at one point as apartments. So let's get to what I drug up today. It looks like the court date has been pushed back to October the 12th. And it does say jury selection will begin on October the 12th. I have marked my calendar. I'm sorry, I said October, August the 12th. I have marked my calendar for that. There was originally jury selection was supposed to begin on July the 22nd, but for one reason or another, they did push it back. I did notice that there has been something filed by the prosecution, and it was a motion to exclude testimony. The gentleman's name is Roy Bedard, and it looks like they're trying to bring him in as an expert witness. So I'll kind of read this to you guys and give you an idea of what this motion says. The state took Dr. Bedard's disposition on Friday, June the 14th of 2024. He is listed as an expert witness currently. Dr. Bedard, based on his deposition testimony, expects to provide testimony regarding defendant's decision to use deadly force and the stress-related factors that contribute to making such a decision. Dr. Bedard has spent the majority of his career training law enforcement and more recently has focused his attention on stress-related issues and how people, including law enforcement officers, perform under stress. Dr. Bedard indicated that he is not a psychologist. Dr. Bedard indicated that his courtroom testimony primarily focuses in the area related to the instant case on how people behave under situations of high arousal. Dr. Bedard discussed signal detection theory, which involves an analysis of what is going through a person's mind when making the decision to use or not to use deadly force, including the moment and type of information at the person's disposal to determine the validity and degree of a perceived threat, and how that threat relates to the time the person has to make that decision. Dr. Bedard also plans to discuss the use of force continuum, a concept that he feels is not adequately explained in Florida statutes or explained to the jury. He hopes to provide the jury with explanations about concepts such as escalation, de-escalation, and proportionality as it pertains to the use of force, to provide the jury with additional information not contained in the Florida statutes to better allow the jury to understand these concepts. Dr. Bedard stated in his deposition that if he is permitted to testify, his testimony is not expected to be an explanation of what happened, but an explanation of how people think during periods of uncertainty under stress. He indicated that he does not plan on testifying to the ultimate issue, that the defendant's actions in using deadly force was or was not reasonable. He stated that he received sufficient information from the defendant's interviews with law enforcement to help him form his opinions. So he didn't meet with her? Dr. Bedard factored into his opinion the history of disagreements between the defendant and the victim and concluded that the defendant was frightened by her environment and the circumstances prior to the shooting, which I'm going to call BS on, because this woman caused more drama than her neighbors did. If she'd have just stayed in her apartment and kept her mouth shut, she'd have been fine. It says, Dr. Bedard stated, "I am not here to educate the jury on the law, but from a self-defense perspective. You can't avoid it when you're making these analyses." Describing the law, he stated, "If a person believes that someone is coming into their house unlawfully, there's a presumption that they are in danger." And to me, it seemed pretty evident that that's exactly what happened. Those elements were met. Now, see, you say that, and I hear him saying he's testifying. He's kind of contradicting what he just said earlier. Dr. Bedard was asked, "It seems like your role in this case is going to more of an educational role to explain or to the jury from a general standpoint, this signal detection that you talk about. What goes through a person's mind in a period of stress? Am I correct?" And the doctor answered, "Yeah." I answer questions. So whatever questions I'm asked, I'll answer. I won't get up there and give a dissertation or a presentation of any type. Dr. Bedard explained that he planned to testify about areas of decision-making under stress that are not well known, and his efforts would be able to teach the jury how to think about situations that most people are not confronted with, but would like to avoid specific discussions about the facts of this case. He indicates that though he did not plan on giving an opinion as far as what was going through the defendant's mind when she fired the gun, he made use statements she made during her interviews about what was going through her mind to explain why a person would feel at the moment and how these factors would cause arousal and stress. Dr. Bedard stated that plans to talk about antecedent things, meaning events that happened between the victim and the defendant prior to the shooting, to explain why somebody would be more cautious. Dr. Bedard acknowledged that there have been instances where his testimony has been limited by prior courts, an issue discussed further below. Now here is the argument put forth by the prosecution. They say that in Jones versus State, the Florida Supreme Court stated that the decision as to whether expert testimony should be allowed into evidence is within the broad discretion of the trial court and will not be disturbed on appeal absent a clear showing of error, and is evaluated under an abuse of discretion standard. Florida Statute 90.702 explains that to be admissible, expert testimony must assist the trier of fact in understanding the evidence or in determining a fact in issue. Courts have also interpreted this language as, is there another page? Okay. Requiring expert testimony to be helpful to the trier of fact. In order to be helpful to the trier of fact, expert testimony must concern a subject which is outside the ordinary understanding of a lay person. Additionally, the Florida Supreme Court has ruled that expert testimony should be prohibited where the testimony is of a nature so as not to require any special knowledge or experience in order for the jury to form conclusions from the facts. They also reference Branch versus State, where the Florida Supreme Court almost 100 years ago held that what constitutes a reasonable basis for the use of deadly force is a question for the jury. Interesting. The court held that ordinarily Whether the use of force and whether the amount used was justified is a question to be determined by the trier of fact. Very good point. Additionally, they referenced Mitchell versus State, where the court addressed the testimony of an expert named Dr. Stephen Edney, who was expected to testify consistently with his report, which stated in part, based on the information he provided during the present examination, it would appear that his actions were not premeditated. That is, his actions were the result of self-defense, as he perceived that his life was in a significant and imminent danger. His perceptions are consistent with his having a reasonable belief in the imminence of bodily harm, death, and he therefore reacted in a manner similar to how other individuals in that situation could reasonably be expected to react. Again, it is documented that Mr. Mitchell suffered harassment and aggression from the individuals involved in this incident over a significant period of time, instilling an overall feeling of fear and anxiety in him. Moreover, by his account, he was unable to avoid the conflict and was forced to use aggression to avoid what he perceived as an imminent threat to his life. They go on to say that the court prohibited Dr. Edney from testifying, found that the doctor would be offering a conclusion on the ultimate issue of fact based solely on Mitchell's self-serving statements. The court explained Dr. Edney's preferred testimony boils down to a statement that based on what Mitchell told him, Mitchell reasonably believed that he had to defend himself or be killed. There is nothing in his testimony which concerns a subject beyond the common understanding of the average person. If the jury believed Mitchell, then it would find that he acted in self-defense. Thus, the issue is not one of which the expert testimony should be permitted. It merely allowed an expert witness to bolster Mitchell's credibility, which is improper. They go on to state that in the instant case, Dr. Better did not interview defendant like Dr. Edney did in Mitchell. However, he did review the interview she provided to law enforcement, which factored into his opinions. Dr. Bedney's testimony would merely serve to bolster the testimony of the defendant provided in those interviews, which is improper. That's true, because he's not really giving her he's not, if you're going to have an expert witness, and I see this way too often. If you're going to have an expert witness, don't they need to examine the defendant to get up there and give a testimony on that? The court examined a stand your ground hearing in a trial in which both the state and the defense called competing experts to testify about the reasonableness of the defendant's use of self-defense. The court, in assessing the experts' testimonies, explained that at trial, in a roundabout way, the experts opined about the reasonableness of appellate's use of deadly force. Neither side objected to the other calling an expert, but they agreed that the experts would not refer to the credibility of witnesses. The court wrote that to ensure that this opinion is not read as tacit approval of this use of expert testimony, we first address the propriety of such testimony in a case such as this. Had there been an objection to either expert, it should have been sustained. The case turned entirely on how the jury evaluated the testimony of various civilian eyewitnesses to the shooting. The experts reviewed witness testimonies and other evidence in the case, personally interviewed some witnesses, and essentially opined on the issue of whether the use of deadly force was reasonable and therefore justifiable under the law. Because neither party objected to the testimony of the experts in general, the court's analysis was limited to assessing whether the state's expert commented on the credibility of other witnesses, which is clearly improper. The court explained, here the experts' opinions on the visibility of self-defense necessarily involved their estimation of the credibility of the competing witnesses, a determination squarely within the wheelhouse of the jury as the finder of fact. So I think we get where they're going with this. Obviously, I'm not going to keep going on this, but they reference several times that the expert witness kind of led the jury. And it says, to finalize this motion, they said, in the instant case, Dr. Better is not a psychologist and does not hold himself out to be a psychologist. He has not interviewed or evaluated the defendant, but instead reviewed her interviews given to law enforcement. Dr. Beddard plans to basically discuss the effects that stress and arousal have on a person's decision to use or not to use deadly force. Though Dr. Bedford may use more complicated terms such as signal detection theory and graphs to explain these concepts, these are concepts that each and every person understands and can comprehend and are not the subject of expert testimony in this context. Though Dr. Beddard appears to plan to supplemental the long-standing jury instructions, which have been deemed adequate through many years of judicial precedent, with his own opinions, such testimony is not proper or admissible. Dr. Beddard has indicated that he does not plan on having an opinion as to the ultimate conclusion, whether the defendant was reasonable or not in using deadly force, though it is clear that his testimony is directed to doing just that by masking the facts of this case through an explanation of theories of self-defense. This is the same sort of testimony that was excluded in Ward. Dr. Beddard's opinion would serve no other purpose than to bolster the statements the defendant made to law enforcement by presenting them through an expert who would then use those statements to backdoor an opinion, as was done in Salomon versus State. Wherefore, the state respectfully requests this honorable to enter an order granting the state's motion to exclude the testimony of Roy Beddard. I could sit here and read his deposition, but honestly, I think the prosecution summed it up because he just went on and on about people's reactions to things. And it's an 85-page document, if that kind of tells you anything. So I want to go back over to Marion County, look at notice of withdrawal of reciprocal discovery witness. That's locked. I can't get into that. It does not look like that was actually ruled on yet, or that it's on the docket, whether they ruled on that or not. So that'll be interesting to see what goes on. Now, again, she is being charged with manslaughter with a firearm, culpable negligence, exposure to harm, assault 2 times, and battery. And as we know, Ajike Owens lost her life. So this will be interesting to see what plays out in court here. I'm going to stay on top of the case because I don't know why, just from the day one of watching all the body cam footage, and there is a ton of body cam footage on this case that I have. So if you're not familiar with that, please go to the playlist that I've created for this specific case and kind of catch up, because that is going to kind of get you ready for what to expect when we get into the court. And hopefully we'll be able to watch this live streamed. So thank you all for joining me here today. Appreciate your time, and I hope that you all have a blessed evening. I will talk to you very soon. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.